selected.
Nothing of the sort. If it had done all of that, it would have been different. Nothing of that sort. This is an illustration. This is exactly the entirety of it. First page and last page. It's not even. It calls itself. Yeah. It calls itself at the top combined merit list for assistant teachers. At the very top, tiny lettering, third line, right above the table, in the middle.
But it says the rank.
That's all it is. Serial number, roll number, name, category.
No, then it says the rank.
And the rank, yes. Rank is because the marks. So last column is rank. Now, just turn to the second page.
Rank is also in serial.
Yes, it's serial. So that is just a simpliciter rank list without going into eligibility, fitness, nothing else. Just a simpliciter rank list. Just see the last second page. We're giving you the first page and the last page.
This is how it is.
It is. So once you clarify that, sorry.
Something, my notes mentioned something very important. The document doesn't mention what are the further steps to be taken, but
Yes.
the appointment letter specifically notes that there is a counseling and then there is a verification. So unless verification happens and then they are given the letters of appointment, the appointments can't be made only on the basis of this rank list. This is something that I just, because my notes put that, I apparently think my notes felt that maybe if there is a rank list in the order of merit, you would probably get appointed in that matter. But that's not so. That's not a conclusive thing for the appointment.
It's like somebody being selected, subject to being unfit.
And several other categories, including when you have to verify that they fall in those 5-6 categories which were listed out, you have to verify that. That is the next step. This is only to show that you've got your chin above the. That's all. So the second page is in fact the last page of the entire list. Marks go up to -20, Malak. They go up to -20 simply because you have to ensure that everybody is given one particular rank. It's transparently done. That's the only reason it is done.
So now, what is the difference between the serial number and the rank? The same serial number and the same rank.
It'll amount to the same thing. It'll amount to the same thing.
No, rank
Because there's no cutoff.
Rank should depend upon the marks obtained.
Yes. Yes. What this serial number is only for showing in the list that we start from 1 and move downward.
Right.
Ranks is the last column to show that as per the marks in the second last
No, it
column.
is not as per the marks. Just see.
The lordship will see total marks, second last column.
As per the marks.
It's decreasing. It's starting from 1 and moving down.
Yeah, as per the marks.
No.
Second last column.
ये क्या सीरियल वाइज सबको ऐसे मिल गए नंबर क्या?
नहीं, जिसका सबसे ज्यादा है मार्क 1 हो गया, उसके बाद जो
अकॉर्डिंग टू सीरियल
नहीं, ये तो सीरियल नंबर ये है।
No, your lordship said you will have to spend a considerable amount. The bench will have to spend.
We do this
tailoring. Yes.
All we'll be doing is tailoring.
And your lordships are told, no, you won't have any tailoring to do. This is a unique.
This is the only one.
This is far more a unique case. It has happened in every other state, and here's what's taken place. In West Bengal, in Bihar, in Punjab, they have implemented your lordship's judgment correctly with the cutoff dates. They have removed a whole bunch, more than 100,000 B.ED candidates have been removed in these states. If your lordships were to entertain this plea of theirs, all of them will come with applications. And I thought they will have to come with applications because I didn't realize until this lunch break that in fact they already have come with an application. Bihar people who have been thrown out have taken this opportunity to file an impeachment application in this matter before your lordship to say, hang on, I also want to get back on the bus. Now, therefore, lots of tailoring will start happening now because they want you to dilute the Devesh Sharma judgment even further than what initially happened. Your lordship's notes in fact a clarification judgment that normally judgments are prospective. But all these arguments on equity were taken there. And after those arguments were taken, your lordship said, look, we're making it very clear. The Devesh Sharma judgment is the cutoff. Now,
No. We said judgments are Retrospective.
Retrospective in nature. Normally,
That they don't lay down the law.
yeah,
They say what the law is.
they say what the law is, they declare. And therefore, those who have moved the core and succeeded would obviously get the relief. But unfortunately, in this case, as far as those petitioners are concerned, your lordships clarified, no, we are making it prospective in nature. But the safeguard that we provided to balance, because I think a lot of the argument went on equities, talking only about the equities of the B.ED candidates in isolation, forgetting that we exist. Like I said, 1 lakh of those candidates who took part were D.EL.ED candidates, fully eligible, who have succeeded. And the government makes a statement before the High Court in the impugn judgment saying there are enough and more D.EL.ED candidates to take care of all vacancies. So there are enough and more of us to hold this, don't have to worry about the students not being taught, etc.
They say even if all of you are given appointment, let's say today,
Yes.
even then there will be vacancy.
That's not correct. That's not correct. And I'm going by the government statement. Your lordships, if your lordship want to see right away, it's page 45, impugn judgment. In the same matter, the state submission, it's para 28. I'm using the paper book in Naveen Kumar. So, item 8. Item 8,
Which paragraph?
page 45. Page 45, para 28. This is the state submissions. In fairness, after this submission, they shouldn't have filed an SLP. Just see page 20, para 28. Mr. So-and-so, Additional Advocate General, submits that since at the time of advertisement, the rules 2019 prescribe the qualification of B.ED as eligible qualification. Therefore, candidates having such qualification have been allowed to participate in the process of selection. However, he submits that the appointment to these candidates have been made pursuant to the interim order dated 29/8/2023. Please note that Devesh is 11/8/2023. The state stand is that the appointments are made under the protection of this court's order dated 29/8/2023. So it's after the cutoff date. Very something they admitted.
This is dismissed from this test.
Passed by the Honorable Supreme Court in the matter of Harishankar and others of the state of Chhattisgarh, which have been made subject to outcome of this petition, and therefore the candidates cannot claim right over the post. Their rights are subject to the decision of this petition. He further submits that sufficient number of candidates having the qualification of D.EL.ED are available in the state. This is the state stand. So there are sufficient number of hours. So the equity there is also in our favor. That we exist and today we are unemployed. We have not been given these jobs which are due to us in law.
They were saying, Karuna, aren't you your brother's keeper? That's what they're saying.
The brothers have been at one like Cain and Abel for long enough, and we shouldn't be. Heaven knows where it will go after this. Now, just a few additional facts on equity. So first, Bihar, West Bengal, Punjab, and Uttarakhand are cases where this hand up. I've given this your lordship this chart, the other side. Just to show what the position is with all the states. Because in Devesh Sharma, the states were considered, all the states were considered, not only Rajasthan. Just see this one. So Rajasthan is the first case where there was a High Court judgment. In the final column, we have given that the decision was affirmed in Devesh Sharma and review petitions were dismissed. But the second last column is critical, which is B.ED appointment after Devesh Sharma. In Rajasthan, it's no, but in Bihar, Chhattisgarh, West Bengal, and Uttarakhand, it's yes. Therefore, your clarification judgment NIOS very clearly on all fours in all these cases.
What is this? Yes, yes.
I beg your
Bihar,
pardon.
Chhattisgarh and Uttarakhand is yes for what?
For appointments after Devesh Sharma.
After the election.
So after 11th August, where appointments have taken place and your clarification judgment makes it clear, if appointments have taken place after that, you're not protected. The other category which is not protected was those who had been appointed prior to Devesh Sharma, but under protection of some court order. But your lordships use the words by them, petitions being filed by them. And the argument was taken and successfully by them in the Madhya Pradesh High Court that by them means only our petitions. Now we obviously had no cause to challenge it, but I've argued that already before your lordships and your lordship said not interfere. That is serial number 9. You see, serial number 9 was that application that I argued before your lordship. That Madhya Pradesh, where I said please modify those words by them, that your lordship were not inclined to. So this shows you a picture that not only in Chhattisgarh, but also in everywhere it said yes. That's Bihar, Chhattisgarh, West Bengal, Uttarakhand, these 4 states. You will have tailoring to do. In all these other states, we are the only ones left. In all these other states, the B.ED have been cast out and the D.EL.ED have been appointed. Completely in compliance. This is the only state that's left. So please don't carve an exception for them, because otherwise all of these will come back and they'll start unscrambling there again. Now, one more. In Uttarakhand, SLP was filed against the High Court judgment, which is in our favor, and there's a judgment of a coordinate bench which is dismissed the SLP. It's referred to there. You also want to see the order.
Simply applies it.
It just applies Devesh Sharma and dismisses it. This is on 8th of April. This is in fact coincidentally on the same day, Manoj, as the clarification order of your lordship. This is date. Judgment is 6th December 23, against which there's after Devesh Sharma. Afterwards, Devesh Sharma is applied. High Court judgment in our favor. This is identical to our circumstances. And I would.
Yeah, Uttarakhand High Court also said you are not.
They're not eligible.
And when they came here, it was this.
It is SLP is Uttarakhand. So identical, same thing should be. The impugned order makes reference to this in fact. The impugned order of the Chhattisgarh High Court makes reference to
things. One thing they are saying, Chhattisgarh is a slightly different. It's a troubled area in the sense that
that argument.
There is a problem there.
But that applies equally across the board. We are both from the same state. I'm the eligible one, and the pedagogy is with me. Against
is with you.
Yes.
They are saying, as far as pedagogy is concerned,
Yes.
they have a bridge course there.
Yes.
The second is then in that Naxalite prone area,
Yes.
there people are not willing to go and teach. They are the one who were taking the risk and going saying that हमको वही भेज दो.
So 1 lakh of the best of us clear candidates have cast our hats in the ring to show our bona fides, and we are all there to take care of these poor tribal children, if that is the argument that they're trying to make. Now, this is an argument that won't cut in their favor in any event. It's the same state. We are the eligible ones. We are the qualified ones. We have the pedagogy. There's no bridge course. How does anything anywhere in their favor? We're all from the same state. It's not like we're different states. And there are enough of us. The state makes it clear there's enough of us. 1.5 lakh have taken.
Enough means you are more than 27,000.
Yes, we are 1 lakh. We are fully 1 lakh. 27,000, my lords, are the vacancies which your lordship were shown in December 23. December 23 is for the next phase after our process is complete. Our process is 6,000. So in our process of 6,000, we're in any case almost 12 times that or more. There are enough and more of us. So that's the state is absolutely right in saying there are enough and more of us. So the question is, if you're arguing equity, where is the equity here? The law is not with you. The cutoff date is not with you. Where is the equity? And this court has already dealt the same blow as far as Uttarakhand is concerned. Should your lordship be taking a different stand? But just one more thing. Just on the dates, and I think that's a little critical.
Yes,
Yes.
rightly or wrongly,
Yes.
the coordinate bench had committed them for the High Court to give go ahead.
Correct.
Goes ahead and the appointment letters are issued in their favor. They are
Correct.
teaching.
So I want to come to that immediately.
Right now, they are teachers
Yes.
who are teaching.
Yes. There are, but there'll be better teachers teaching because we are the ones with the pedagogy without the need of a bridge course, which has still not been brought in for that state. So let me just answer that. The dates are a little important. 30th May 2023 is the first writ filed by us. That is at page 510 of this. Your lordship will find our prayers. because I think there was an argument made that we didn't challenge the rules, etc. Second prayer squarely challenges the rules. That's at page 510. So that's the first of the writs. On 11th August 23, the judgment in Devesh comes. We have filed an application before the High Court asking for interim orders. On 21st of August 23, and this is relevant, 21st August 23, the High Court grants us the interim relief relying on Devesh. As a result of which, the B.ED are not permitted to be appointed. That's at page 584. 584 of the same volume.
All right.
At page 586, I'll just read one sentence. The Learned Counsel for Petitioners submit that earlier only D.ED candidates were allowed for appointment on the post of assistant teacher, but by NCT notification dated so and so, D.ED at par has been included. But Honorable Supreme Court in very recent Kumar's SLP.
Yes,
Yes, 584. This is an order of 21st August 23, my lord.
Yes.
At 586, second line, but the Honorable Supreme Court in very recent judgment, this is 17 days prior, that's why very recent, on 11th August, held that only D.ED candidates are eligible for appointment of post of assistant teacher, and the inclusion of B.ED is illegal, quash notification dated 23rd August. And accordingly, rules of state of Chhattisgarh regarding inclusion of B.ED has also to be held as ultra vires. He therefore prayed for staying the further recruitment process at the final disposal of the petition, etc. And then, considering the arguments advanced, and they make a reference to Devesh Sharma at the bottom of the page, the further recruitment process shall be kept in abeyance with immediate effect, and further no final decision will be taken. Right now, against this, they come in SLP before your launch. That is at page 591 and 592 on 29th August 2023. At 592, your lordships note, after noting the CA 5068 in the second paragraph, at 592 bottom para, therefore to the said extent we hereby stay the order dated 21st August passed by the High Court and clarify that the recruitment process which was in progress prior to the date of interim order shall continue, and the appointments, if any, made thereunder will however remain subject to the result of consideration to be made by the High Court in writ petition so and so. So your lordship make it unequal here that this will be subject to the impugned order. Now the impugned order has come. They have to abide by the consequences of it. There's yet another reason why they have to abide by the consequences of it. And now the shoe is on the other foot, at least this time, I guess. That clarification order of your lordships. Can I just show your lordships that for a minute? 8th April 2024 at page 651. Just further on in the same volume. Page 651. At bottom of 651. Page 651. I'm just at 651. This is the 8th April.
As it appears.
Last three lines, yes, as it appears, that a large number have already been appointed on the basis of eligibility criteria, etc. We do not think it equitable to effect the removal. We accordingly hold that the judgment dated so and so shall have prospective operation. But prospective operation of this judgment shall be only for those candidates who are appointed without any qualification or conditions imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have been instituted by them, and such candidates were in regular employment without any disqualification. Now you have to be in regular employment. They were clearly not in regular employment also on that date, on 11/8/2023. That is very unequivocal what your lordships have said. On 11/8/2023, they were being told by the High Court that this recruitment process is being halted. They came to the Supreme Court, and the Supreme Court said that look, it can continue subject to the outcome. Now the outcome has come. And this makes it clear that they should have been in regular appointment on that date. So the next sentence, you say, we make it clear that this benefit is only for the candidates who were appointed prior to the date our judgment was delivered on 11th August 2023. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under our present order. Which is the benefit they're seeking today? They're seeking a review of this order, and they're saying mere selection should benefit me. So please give me the appointment which I am not permitted to get under either this order or under the principal judgment they wish. The appointment letter, which was issued to them at page 594, records this. So they are abundantly put on notice about each of these. 594, right? So page 594, Manoj. Now, page 594 is the appointment order, which notes first. Well, this is one of the appointment orders. It's 29 September. The about 4 lines from the bottom at 594. No, this is 594. Yeah. 4 lines from the bottom. On date 2nd July for the advertisement.
G. Vyapam.
Yes, sir. G. Vyapam. On
Date. Vyapam coming in.
It's a website.
That's the agency which conducted the examination.
Yes, it's an agency website.
Vyapam is
Yes, sir.
Very famous. Very famous. One gets alerted. But fortunately, so far as Vyapam of Chhattisgarh is concerned, there are no.
just on the lighter side, otherwise you get.
Your lordships are right. Your lordships are right. In Madhya Pradesh, there were quite medical admissions
Yes,
and
Vyapam.
CBI cases, and people were arrested, and lots of things happened.
That is my brother is hinting at.
Vyapam was Vyap.
Yes, absolutely. Lordship.
Chhattisgarh is a better performing state.
So it says, last 3 lines, the verification of documents was made from 8/9/23 to date 13/9/23. So this is also after the cutoff dates to show that even though there was one 2,400 page list which came on 2nd July, their own counseling process started only from 8th September and went on to.
They are accepting.
They're accepting. But page 599 is all I wanted to show you. Page 599, para 12. 599, para 12. This is part of their appointment letter.
What are you showing us?
This is their appointment letter. 594 is the appointment letter.
P20.
P20, yes, sir.
It's an appointment letter.
This is an appointment letter.
Oh. Whose appointment here?
Last sentence, if I can read at 594. After verification from the date of taking over charge on the post of so and so by the candidate, temporarily on probation for 3 years, so they're on probation till further order. Appointment
This
made
is Naveen Kumar.
Naveen Kumar. That's the name. The details are given. He's a B.ED candidate. Now, the terms and conditions start at 596. At 599, para 12, they say the aforesaid appointment shall be made subject to the final order judgment in SLP so and so. That is the SLP in which the interim order had come, saying please go ahead subject to outcome. That eventually came to be disposed. Page 599,
Paragraph 12.
599.
para 12, bottom of the page.
That's the aforesaid appointment.
Yes, so it refers to two proceedings. One,
You have translated, the translated version you have.
I don't know. It's theirs, Manoj. I presume it's their translation or
Yeah.
original. Must be Hindi. Most of these are Hindi.
The official language is Hindi.
Hindi, yes. Most of the documents that I'm seeing is Hindi, so it must be
It
translated.
refers to SLP and
SLP, and it refers to filed in the and the red petition 5788, which is the one out of which the appeal judgment arises.
yes.
So both are added items then. Even the appointment letter makes it clear.
There is
that
a
the
reference of
appointee
another SLP before the Supreme Court.
and SLP diary number. What is the diary number? 35225. This is the one.
592 is the reference.
This is something else.
Okay.
This is the one.
The diary number 35325 is the one out of which that interim order came. The Supreme Court.
Yes, 592.
Yes.
788. That's a revocation.
So it said subject to outcome.
The next
Now,
is SLP.
if you see this appointment, it's in September of 23. The impugned judgment is 2nd April. It's barely 6 months. That's all it is. So they have barely started off in their probation period. And now they're making a song and dance about the fact, oh, look, we have been recruited, we have been there in the saddle for so long. And this is not one of those cases. I can understand hard cases where you've been 7 years in courts, etc. Barely 6 months, you had an interim order. The Supreme Court put you on notice, the High Court put you on notice, your appointment order puts you on notice. So this is perhaps not the kind of case where they should be making the shindig about it. This is where you must, I think, gracefully exit, as similarly circumstanced people have done in Punjab and UP
Other states.
and Bihar. This is perhaps not that. Now, one additional point regarding the judgment in Devesh Sharma starts at page 520. I just wanted your lordship to see two specific things, which are paras 5 and 10, which is at 524.
Five.
Page 524. Yeah, if your lordship to use the PDF, I'll try and give you the PDF. 560. PDF 560. Now, page number is 524. Para 5.
Para 5 I have got.
Your lordship.
PDF never works.
It's not PDF 560, is it?
5, you said 5?
60.
Which page you are referring to?
Para 5.
Yes, I have.
Yeah. Para 5 and 10, I want to show you. Para 5, out of the 3 writ petitions, because apart from the SLPs from Rajasthan, there were these writ petitions. Out of the 3 writ petitions before us, 2 are challenging the notification dated so and so, and the subsequent notifications issued by the governments of Bihar and UP, respectively calling for application from eligible candidates, including so and so, is against an interim order of Calcutta High Court. So West Bengal, Bihar, UP. Now, your lordships were aware of the fact that these disputes were going on in various states. So see please, para 10. Next page, 526.
During the course.
During the course of hearing, para 10. During the course of hearing, this court had passed an order dated 24th August 22, granting liberty to the Board of Secondary Education for different states and other stakeholders to be included as interveners. Pursuant to this order, several interlocutory applications were filed, which are being heard along with these appeals. So now, if they choose not to come, either the state or any of the other petitioners before your lordship, when they are aware that the very same notification, very same qualification is up and being examined, and your lordship have gone out on a limb to actually pass an order and say, please come, if any of you have to file intervention. Many people did. Many individuals filed intervention. Ms. Grover was there. Ms. Arora was there, and she had argued this case. So many states, many other interveners, individuals, etc., had all been there, and they had taken part in these proceedings. So for them to say that, look, this took place somehow behind our backs, and Chhattisgarh didn't have an opportunity, Again, your lordship will recall when the Madhya Pradesh application was moved, which your lordship treated as a review and passed that clarification order. There were other states present, candidates from other states also present. So I think it's too late in the day for them now to say that look, Devesh Sharma actually took place in the dark, and we were not privy to that. One further thing, we have RTI responses which show us that there is no such bridge course in the state of, that is it, first copy. This date of action this is to NCT, the NCT is required to set up the bridge course.
Is only the application.
So it says
Which was done by, and in some cases it has been done by some open universities and.
yes, but that's not recognized. It needs to be recognized.
There is a problem there.
So section 23 is
that norms and standards for 6 months.
I didn't interrupt my friend. I'm sure.
Clarifying.
No, you don't need to clarify until I've read it.
Yes.
So the response is dated 14th July 21, and the reply, which is the 7th column there, says the norms and standards for 6 months bridge course has not been drafted so far. Now, one thing your lordships were unequivocal about in the main.
This is which date?
14/7/21. Date of action is 14/7/21.
So we are 3 years ahead of it.
The document that was handed over by my friend to your lordship was 2017. He had to back up to say that 2017 itself we have a bridge course. In 2021 they don't have a bridge course.
Forget the bridge course, there is no bridge also.
There's no bridge also. Clearly, that's also. I mean, that's Bihar, but here also.
They just collapsed.
So,
It's an appropriate case of collapse.
if your lordships in fact sees section 23 of the RTE Act, it is unequivocal that it is only the specified authority, which is NCT, which can lay down the qualification. The relaxations in that under 23(2) can only be by the central government. State government has absolutely no role to play in any of this. So they can't set up some sham bridge course of their own and say we have a bridge course, if at all that is their argument.
No. It is not, you can't call it a sham in that sense because,
yes,
see, when this judgment was being argued and I mean this case was argued, judgment was to be written.
yes,
It's all the documents, you know.
yes, yes. You're
Part of it is over, you argue and then it's over. The difficulty starts there.
That's true. That's true. No, but your lordships have in fact extracted every letter.
When they go to the file,
Yes,
there is a correspondence which says that there is a bridge course.
yes,
Central government, because it's basically central government's baby.
correct. It is.
They wanted to push it because the central school wanted it for
Correct.
some reason. We don't know.
Correct.
And there it is said that bridge in many courses, bridge courses, some module has been prepared,
Yes,
underway. There was something like that.
yes,
But then this is the bridge course.
correct.
But the idea was that in the next education policy, they are coming up with a combined 5-year course.
Yes.
If that comes in, then this B.ED, LT, there is no problem then.
So they came out with the National Education Policy in 2020, which specifically provided for that so-called 5-year kind of.
There is just a mention, nothing has happened.
Nothing
It's a
happened.
policy.
Still not been implemented. Still not been implemented till date. In fact, your lordships were conscious of this. So when you gave your findings eventually and said that it is arbitrary to bring in a B.ED course, you also made one further observation which is critical, which is that it is not that the B.ED is a higher standard. The lordships have given the
Yeah, it's
conclusion.
a qualification.
The only logic given by the central government to include B.ED as a qualification is that it is a higher qualification. This we have already seen is not correct. But that is precisely the argument being made by the state just now. Mr. Nadraj said it is a higher qualification. So using the motor vehicles judgment, the 1994 motor vehicles judgment, he relied on that to say states can provide higher norms, higher standards. Lordship recall just before lunch, he handed up the 94 days. It was for that. To say that therefore states can develop higher standards, etc. But your Lordships have said it's not a higher standard. So even that tiny avenue which is available to try and somehow protect them, I don't think that either stands. Because I don't know. So I don't believe notice shouldn't be entertained at this stage. That's all I have to say. I just wanted to take your Lordship through the background. I'm grateful.
But my learned colleague has covered much of it. I won't be touching on it. But it was just one thing that, if I may, yeah, I want to have that. I may just put it on very briefly, very distinct, separate, very brief points.